In their motion, the government has made two significant errors, each of which have been endemic in this case. One, they have ignored the prior order of this court, and two, they have seemingly relied on their own assumptions based on open source, i.e., Googling information instead of employing actual investigative methods to determine the accuracy of their arguments. Both errors are fatal to this motion. Oh, man. Brian Steele, Marissa, Drew, Christy. Put the belt today. Let's go. Third Bank's response to government's motion in limine number 4 to preclude defendants from offering their own prior statements. And we got the hearing date for August 13th. I might pop up at this thing. Defendant Dirtbags through his attorneys, Drew Fillin, Marissa Goldberg, Brian Steele, and Christy O'Connell, hereby files this response to the government's motion in limine number 4 to preclude defendants from offering their own prior statements. This response is based upon the attached memorandum of points. I don't know why I just said it that way. Anyways, and authorities, the files and records in this case in such further evidence and argument as the court deems appropriate. Now, let's really dig into this. It just says the government filed motion in limine number 4, seemingly generally to preclude and/or limit admission of statements of Mr. Banks and/or alleged co-conspirators, which he may use during cross-examination of witnesses. Mr. Banks is cognizant of the jurisprudence which prevents him from offering his own statements and evidence without opening himself to cross-examination, subject to be allowed to avail himself of the ability to introduce additional portions of a prior attached statement under rule of completeness or other applicable rule. Then it goes on to talk about Rule 106 as the rule of completeness, in explaining that the rule allows a party to introduce additional portions of a document or recording when her advisory admits only a portion of the document or recording. Then it goes on to talk about statements that would otherwise be inadmissible hearsay are admissible under Rule 106 for the non-hearsay purpose of minimizing the risk that the jury will be misled by the government's selective editing, which means they're not going to show the whole entire thread. And that's where we talked about this shit in damn near like 10 videos. The feds are always going to cherry pick because, hell, the defense would too. But anyways, it goes on to say the rules of evidence will not allow the government to admit misleading snippets of defendant whilst out-of-court statements as party admissions, while excluding other out-of-court statements that provide context to the government's evidence. In anticipation of evidentiary disputes, the government proposes that the court order Mr. Banks to, 1, provide the government and a court a preview prior to each trial day of any statement of Mr. Banks or co-conspirator purportedly admissible under Rule 106, and 2, that Mr. Banks be required to provide the government with notice of the statements that he intends to use in his case in chief no later than 1 week before trial. Mr. Banks does not intend to engage in any conduct which would create a delay of court proceedings. However, there are concerns with the identification or production of evidence to the government pursuant to the suggestive timeframes. The trials are fluid, and the use of a statement will necessarily depend on how and when the government introduces the evidence on direct examination and what the witness states. As to the request to produce any statement of Mr. Banks or any alleged co-conspirator purportedly admissible under Rule 106 prior to each trial day, that could become problematic as the timing, length, and content of a witness testimony is unknown. As an alternative, Mr. Banks would agree to notify the government of any Rule 106 materials at or before the commencement of cross-examination of the witness. The government also seeks a court order that Mr. Banks provide them with notice of the statements that Mr. Banks intends to use in his case in chief no later than 1 week before trial. Mr. Banks has informed the government that they may use any of the statements which the government has produced in discovery. Require Mr. Banks to specifically identify what statements he intends to use in his case in chief may not be possible because Mr. Banks anticipates introducing all relevant information on cross-examination of witnesses during the government's case in chief. If that changes, Mr. Banks will alert the government of which specific statements will be used as soon as they are identified, but no later than prior to the commencement of the defense case in chief. Wherefore, Mr. Banks respectfully requests a hearing on this motion and at the conclusion of the same, asks the Honorable Court to adopt the suggested timeframes set for above the identification of Rule 106 materials. Basically, the feds are saying, yo, stop talking. And then the lawyer's like, you already spoke. Y'all put out these editorials. Y'all already did all this shit. So you can't say what we can't do when y'all put all of this shit in shit that's not even in the damn final evidence. So hell nah. If anybody's prejudicing anybody, it's y'all. But don't worry, got a lot more to go. Defendant Durk Bank's motion to government motion in limine number 1 for a limited gag order prohibiting extrajudicial statements. Then they talk about, obviously, what they're about to do. And let's just get into it. Memorandum of points and authorities. At the bottom, the government's motion requests a pretrial gag order that would prohibit counsel's extrajudicial statements on the following topics: the character or reputation of the parties, the expected testimony of a party or witness, the strengths and weaknesses of any party's case, evidence that has been ruled inadmissible and which would create a substantial risk of prejudice if disclosed. Mr. Banks does not believe that a gag order is necessary. Counsel for both parties are ethical and professional. The court should deny the government's motion as unnecessary and unripe. Should an issue arise, and it likely will not, the court will act accordingly at the urging of the complaining party. Any resulting gag order should be narrow, confined at the very most 2 categories 2, 1, 2, and 4. Above, a gag order that would prevent counsel from expressing opinions on the strength of his defense, a prohibition that would potentially prohibit counsel, for example, expressing confidence in a favorable outcome for Mr. Banks, would be overboard and unfair, given the government's history of publicly aimed statements on Mr. Banks' guilt. The government's narrative predominates. The government has propounded a very public and very detailed narrative of Mr. Banks and co-defendant's guilt, complete with a laundry list of purported evidence against him, some of which could never reasonably be expected to be admitted at trial. It would be unfair to hamstring the defense in a way that the government has not limited itself. The indictment or information must be plain, concise, indefinite, written statement of essential facts constituting the offense charged. Federal Rules of Criminal Procedure 7C1. The indictment against Mr. Banks, 4 of them to date, run roughshod over Rule 7's conservative prescription. At the risk of ringing the bell, we touch on but a couple of examples of how the indictments here have been aimed at public consumption. They mention one co-defendant was previously acquitted of murder, a fact that no attorney in good faith could reasonably expect to be admitted at trial against him. They include unnecessary photographs of scary masked gunmen, a car allegedly being tailed through the streets of Los Angeles, and an unreleased music video. This, after the court had ruled that music videos were generally inadmissible. Oh shit. There is no reason to include photographs in an indictment except to influence the public's opinions about a case, as one would expect. Each new indictment has been covered in detail by the likes of Rolling Stone, Yahoo News, LA Magazine, Complex, The Source, and various radio shows and podcasts, including the biggest one ever, Setting Nash and the Visionaries. The press coverage is as recent as the date of this filing. In addition to its speaking indictments, the Department of Justice has built a case for Mr. Banks' guilt through multiple press releases that reiterate the government's evidentiary narrative. See Department of Justice, criminal rapper Lil Durk arrested on complaint alleging he ordered murder attempt that resulted in fatal shooting near Beverly Center, October 25, 2024. Then it literally lists a whole entire government website. Department of Justice, Chicago rapper Lil Durk charged in superseding indictment, alleged murder for hire plot to kill rival near Beverly Center Mall in 2022, November 8, 2024. Boy, this guy Brian still written all over it. The type of petty that they coming with, I haven't seen who wrote this shit, but boy, I know my boy Brian, and this sound like his ass. Justice, government, he just basically listed up the whole government website. You know what I'm saying? When you see justice.gov, that's from the feds. Those press releases contain unnecessary and prejudicial editorializing that reemphasize facts in the speaking indictments and mention additional facts. Among other things, emphasizing how the charged crime, a cold-blooded murder, endangering innocent people at a busy intersection, is devastating to our community. A gag order is not necessary and the government's proposal is overboard. A gag order is not necessary here. All defense counsel are capable of behaving ethically and reasonably. Should a future need arise for the court's intervention, Then, in fairness, given the press coverage the government's own statements have garnered, and in order to comport with the Constitution, the gag order should be narrowly tailored. We observed that the district court did not impose a no comment rule, but instead left available to the parties various avenues of expressing, including assertions of innocence. General statements about the nature of an allegation or defense and statements of matters of public record, we do not believe that there can be a blanket prohibition on certain areas of comment. A per se prescription without any consideration of whether the particular statement posed a serious and imminent threat or interference with a fair trial, any future order, if necessary at all, should not limit the defense counsel's ability to express an opinion on the strength or weakness of either party's case or on a client's innocence. Conclusion. The government should not be permitted to throw rocks and hide its hands throughout this case. Bruh, this sound like Brian, man. The government has conducted itself with an eye towards the press. Mr. Banks has responded on occasion in an attempt to balance out the public's perception. No court order is necessary here. In the unlikely event it becomes necessary in the future, it should be narrowly tailored and should not prohibit defense counsel from opining on Mr. Banks' innocence or strength of either party's case. Who wrote this? He ain't put it on there. I want to know our plan, but we won't know our plan until your people basically get on there, and then we can hash it out. And on top of that, bro, don't try to bring in parts of no text message. Read the whole entire thing, and that's what we've been saying. That could be good or that could be bad because the team may not go far enough, and that allowed the feds to go even more. So that one you got to be a little bit careful on. Defendant Durk Banks' response to government motion in limine number 2 to exclude irrelevant evidence and arguments pursuant to 403. So let's just go ahead and get into it. The parties agree. Jury nullification is impermissible. The government moves to preclude Mr. Banks from engaging in jury nullification. The government is correct, and Mr. Banks agrees that jury nullification has no place in a federal trial. In other words, both parties agree that irrelevant evidence is inadmissible. The defense does not intend to introduce evidence about Mr. Banks' endorsements, fan support, celebrity business, and/or music collaborations, his charitable contributions and philanthropic activities. Bruh. This is petty. It would surprise me if Brian still wrote all of this shit. Yeah, man. His potential punishment, his family, and any other personal factor unless the evidence has some bearing on a fact at issue. If one of these topics become relevant at trial in the defense's good faith judgment, the government disagrees with that assessment, then it can object at trial, as the defense will do in turn when the shoe is on the other foot. Despite the parties' agreement on this, Mr. Banks responds only to point out what the government's motion does get wrong. The charging documents touch upon issues related to Mr. Banks' defense. The case against Durk Banks exists only because the government has over-relied on the world of dubious cooperators, failing to sufficiently scrutinize their stories, which we've been saying. It also exists because the government insists upon conflating art with literal self-incrimination. That is the truth. And as such, it will be the heart of Mr. Banks' defense at trial. As described below, when the government seeks to preclude any reference to any former charging instruments, it seeks to dampen Mr. Banks' ability to explore these themes at trial, as is his right under the 5th and 6th Amendments. The lyrics issue that the government now seeks to exclude from trial, along with one facet of what makes the government's bounty theory so problematic, are illustrated in the various charging documents and speak directly to Mr. Banks' defense. He is entitled to explore them at trial. The government may not use the happenstance that these themes appear in charging documents to shoehorn in otherwise inadmissible vicar evidence. Basically saying, y'all tried this shit already. Y'all can only get this through the damn RICO. And that's the second trial that y'all basically really not even going to pursue. And if you do, you're going to lose that shit. The lyrics issue. By now, the court is well aware of what Mr. Banks will refer to as the lyrics issue. In sum, for a significant portion of the government's investigation in this case, it was under the false impression that Mr. Banks' song Wonderful Wayne and Jackie Boy was a literal confession about the charged murder of SR and attempted murder of TB. Of course, as even the government must now admit, the song could not have been a confession to an August 22 murder because it was recorded in January 22. See docket number 1351. As the government must now admit, although there is a fan-created version of the song on YouTube that references audio from the news clip taken shortly after SR's murder, Mr. Banks is not responsible for what his fans create. That's even assuming that they're his fans anyways. The government's misimpression was born in PW1's lies. Per government-produced discovery, it survived because the government's failure to subject PW1's word to any sort of meaningful scrutiny. It led to the presentation of false evidence to a grand jury and an indictment based on that false evidence. It also led multiple search warrants predicated in part on that lie. And it iterates each time that the government attempts to cast Mr. Banks' music as literal confession, as it will continue to do during this trial. For these reasons, the lyrics issue is fair game. The false allegation regarding bounty issue. This lyrics issue has a fraternal twin. In the first superseding indictment, the government alleged that Mr. Wilson paid out Mr. Banks' bounty to co-conspirators. Remember, we talked about this shit. It says an indictment reads, following the attempted murder of TB and the murder of SR, defendant Banks sought to commercialize SR's death by rapping about his revenge on TB with music that explicitly references audio from the news clip taken shortly after SR's murder, where TB screamed, "No, no," after seeing SR's body. First superseding indictment, Mr. Banks' motion to dismiss based on false evidence presented to grand jury. Then second superseding indictment, removing falsity regarding the song's lyrics, which means the feds knew that the shit was fake, so they had to take the shit out. Mr. Banks' request for grand jury materials related to the government and government witness misstatements to the grand jury remains pending. SR's killing at the direction of defendant Wilson would pay the bounty and monetary reward or cause payment to be made for the killing of SR on behalf of co-conspirators known and unknown to the conspirators hired to kill TB. The second superseding indictment notably omits this allegation. Like the lyrics issue, the lie about Mr. Wilson paying out this bounty originated with PW1, per government-produced discovery. Before inducing the grand jury to charge based in part upon it, the government failed to scrutinize PW1's word, as was the case with the lyrics issue. It turns out that the allegation that Mr. Wilson stayed behind in Los Angeles to collect and pay out Mr. Banks' alleged bounty proved to be demonstrably false, contradicted by fight records showing that he did not. The government's murder for hire charge necessitate proof of bargain for consideration. This sequence demonstrates that the government has failed to properly scrutinize its witness stories on that point. An example of its bias in favor of its unreliable witnesses, believing what it wants to believe instead of what the evidence corroborates. Remember, we said these cats are just lying. Y'all didn't want to believe it. Mr. Banks is entitled to undermine the reliability of the government's investigation and witnesses. A defendant is entitled to elicit at trial details of an investigatory process that potentially affects an agent's credibility and, perhaps more importantly, the weight to be given to evidence produced by his investigation. Plain error and abuse of discretion to prevent jury from analyzing the quality of the government's investigation, which illogically removes from the jury potentially relevant information, when the probative force of evidence depends on the circumstances in which it was obtained. By those circumstances raise the possibility of fraud. Indications of consciousness police work will enhance probative force, and solvency work will diminish it. Discussing the utility of attacking police investigation as shoddy. Further, it should go without saying that the Sixth Amendment right of confrontation includes the right to undermine the credibility of government witnesses through cross-examination. This includes attacks on witness credibility directed towards revealing possible biases, prejudice, or ulterior motives of the witness. The partiality of a witness is subject to exploration at trial and is always relevant as discrediting the witness and affecting the weight of his testimony. Cross-examination on government shoddy investigation and witness credibility does not open the door to severed counts. The government seems to argue that any mention of non-operative charging document at trial would open the door to counts that the court recently severed or other bad act vicar evidence. But if this is true, There was never much of a door in the first place. This could not have been the court's intention when it ordered a severed trial. Reading between the lines of the government's motion, it seems that the real danger at trial will be that the government will take any opportunity to attempt to introduce Vicar-related evidence. It is that danger, not the imagined specter of the jury nullification against which the court should protect. Conclusion. For the reasons set forth above, the court should deny the government's motion in its entirety. The defense does not intend to seek the introduction of irrelevant evidence or engage in jury nullification. In fairness and under the Constitution, the defense is entitled to probe the government's shoddy investigation, even where that shoddiness is evidenced by an inoperative charging instrument. Government like, nah, don't talk about the whole shit. Nah, stay to this shit that we talking about. And the team like, hey, bruh, nah, we want to show how bad this shit is. And that right there, to me, is the most important motion. Because all you need is about 2 or 3 bad witnesses. I don't give a damn if y'all bring in, hey, if y'all start bringing in these bad witnesses and all this shit, and I can show that they full of shit from the first time they spoke to you to the last time they spoke to you, that damn snitch, witness, whatever y'all want to call him, no good. Because he misled y'all the first time and they just proved it. We've been telling y'all this from the jump. I'm telling y'all, Lil Durk is going to win this shit. Further on. Defendant Dirtbank's response to government's motion in limine number 7 to admit self-authenticating business records. Memorandum of Points and Authorities. Pursuant to Federal Rule Evidence 90211, the government provided notice of their intent to introduce business records, provided Mr. Banks with business record declarations supporting the copies of the records sought to be introduced. Mr. Banks objects to introduction of records set forth below based on specific deficiencies in the certification of the records custodians. Mr. Banks reserves the right to withdraw his objection or supplement it based on any substitute certification of records which the government may provide. The government Exhibit 207, the Declaration of Custodians Certifying Business Record, is unsigned, meaning they just put the shit up and nobody said, oh, I looked at it. Moreover, it is not clear what the job/position of the signor is to qualify him/her for being a custodian of records. Exhibit 311. The Certificate of Authenticity of Business Records do not assert that an original or a true and accurate copy of the record has been produced, meaning y'all could have just got any damn thing because any damn thing was available. Exhibit 339 through 341. The Certificate of Authenticities of Business Records does not assert whether an original or a true and accurate copy of the record has been produced, unless and until the government cures the deficiencies in the custodian certifications. Mr. Banks objects to the introduction of the above referenced government exhibits pursuant to Federal Rule of Evidence 803.6 and 902.11. Brian Steele wrote this shit. I know Brian Steele, right? He wrote all this shit, bro. This sound like Brian Steele went and got his money. You know what? Hey, get your checklist in order. Y'all can't bring in shit that y'all don't even have signatures on. Y'all just got shit just saying, oh, this is this, this is this, this is this. How do we know that the proper person even authenticated this shit? How do we know that? Oh, because we don't. So make sure all your T's are crossed and all your I's are dotted before you even let this shit in. And we're going to be fair. That's the only way that you can do it. Defendant Dirtbank's response to the government's motion in limine number 5 to admit the Piss Me Off music video and audio. This ought to be great. Introduction. In their motion, the government has made 2 significant errors, each of which has been the endemic in this case. They have ignored the prior order of this court, and they have seemingly relied on their own assumptions based on open source, i.e. Googling information, instead of employing actual investigative methods to determine the accuracy of their arguments. Both errors are fatal to this motion. The prior order of the court regarding music videos, that's plural. On February 13, 2026, this court issued an order after the February 9th motions hearing that was comprehensive and clear. In a relevant portion, this court disallowed all music videos from the trial of this case, unless one of 2 criteria were sufficiently met by the government. First, The court left open the possibility that as the government claimed a particular music video was proof of the bounty rewarded to alleged co-conspirators in this case, they could seek its admission. Second, the court left open an allowance for one music video solely for the purpose of depicting a relationship between defendant Wilson and others, assuming that the particular video is not unduly prejudicial. The government seeks the admission of a music video entitled Piss Me Off and does not even claim to have made this request under one of these two categories. There is no justification given for why the government has ignored the prior order of the court. The government argues that the lyrics are in imagery are relevant and material to issues the jury must resolve at trial. They make many of the same arguments they made before the court in the prior briefing and at the February 9th hearing that this court had already rejected. They offer no explanation for not including this song in their prior disclosures. This video has been publicly available since 2021. Nor do they explain why they are following the court's clear directives in the order. Even if the government had attempted to follow the court's order, they would fail. This video could not have been a bounty reward for the alleged actions in this case because it was made and released prior to the allegations in this case. I'm sorry, hold on. The video also couldn't have been proposed to show the relationship with defendant Wilson, as Mr. Wilson is not in the music video. Therefore, since the court has already made clear that the arguments made by the government are insufficient to admit a music video, the video portion should be summarily rejected by this court. The government has falsely represented the meaning of the song/lyrics. Duh. They're all Republicans from Donald Trump. They still listen to Snoop Dogg. No disrespect to Snoop. Love you, Snoop, but nigga, they listening to you, cuz. As has been a repeated pattern in this case, the government seems to look at Mr. Banks' videos and lyrics and pick and choose how they want to portray the meaning in this case. With substantial and material omissions to the court, the government argues to the court in their motion that these lyrics reference a get back for the killing of Davon Bennett. Defendant criticizes those who would continue living life as if King Von had not been killed, as opposing to seeking revenge. The government fails to mention in their filing that the majority of the song is actually about Mr. Banks' brother, who was killed outside a club in Chicago just 4 months before the release of this video. Mr. Banks starts out the song with a lyric, "Long live D-Thang," which is the moniker of his brother. The lyric that the government falsely attributes to revenge for King Von. "You ain't get back for your man, you in the club like he ain't dead," is directly after the tribute to his brother, and therefore is clearly Mr. Banks' artistic and emotional response to the killing of his brother. The next group of lyrics is a reference to how he was a victim of a home invasion just several months before. "Niggas ran inside my crib, but the Glock 10 was by the bed. I'll get my gun in India before I put it in your hand." There is no argument that this event is relevant to the case at hand, nor does the government even attempt to make one. Mr. Banks then returns to talking about his brother. "All us, bro, I can't be happy till we creep up on the skull. I know niggas act like they with it, but they bitches on the low. Why you niggas posting son? Why you niggas posting true? Why you act like you support us if you do hop in that coupe?" Why the government mentions the name True in their motion, they fail to mention that Son is a nickname given to his brother's child because it doesn't fit their narrative. We kind of said that. These purposeful omissions are deeply concerning. Similar to the above, the government mentioned that Mr. Banks is wearing a shirt that says "Long Live Von." They failed to mention that those words are only visible for a split second in the song because the top portion of the shirt that is visible for nearly the entirety of the song says "Long Live D-Thang." He is also wearing a necklace that is a tribute to another friend that was killed. All of this is just an artistic in memoriam. Too many people he has lost and not specific. Too many people he has lost and not specific to anything relevant to this case. Assigning a specific meaning to the lyrics in the context of the whole song is, at best, confirmation bias, and at worst, intentionally misleading. Means you fucking lying. The government also makes a mention that there's a Von lookalike in the video, which is factually incorrect. The producer/director of the video took artistic liberties and spliced old footage of King Von into the video. It is not a lookalike, you stupid sons of bitches. Respectfully. Not saying it in a disrespectful way, but feds, y'all fucking suck at this and you're about to lose. An easily dispelled inaccuracy, such as this one just goes to show the uninformed flippancy in which the government views this evidence. The government fails to look past the surface and conduct any real investigation into evidence they seek to introduce into the trial of this case that carries very serious consequences. Lastly, the government yet again fails to listen to the court and assuage the concerns that it didn't give the court foundational information about the song and or lyrics. In its order, the court noted there is virtually no evidence of the timing of when these lyrics were written or even recorded because the government only named the punitive premier dates. They do not better here. Mr. Banks making statements regarding guns, ski masks, settling scores, and stolen cars are clearly prejudicial. The video imagery contains stacks of cash, jewelry, and men in ski masks making motions with their hands as if they were guns. They carry the risk of inflaming jury bias and prejudice with very little probative value to add to this case, as stated above. This carries the very real danger that the jury will assign undue and inappropriate weight to statements made nearly a year prior to the alleged incident. The best evidence of the likelihood of misperception is that the government is obviously confused as to what certain lyrics mean. If they can't straighten this out, neither can the jury to be expected to do so. Conclusion. The court already told the government what they had to do regarding the music and lyrics evidence, and they clearly made no such attempt. The recitation of facts in relationship to the lyrics was stretched and contained substantial misleading omissions. This music video will do nothing to better the jury's understanding of the facts of this case and will only cause confusion and bias. The court should deny this damn shit. This is written by Marissa Goldberg. Damn, she wrote this shit flawlessly, and she wrote it short. Y'all heard of the phrase cherry picking? Only getting the good ones and all this shit? We already called this shit out from the jump. When we read the motion, I think majority of the people who were watching at home was like, do the feds not know this shit? And we even said everything that they just said. First off, y'all don't know that was somebody's son, and y'all didn't know that was the real King Von. So think about it this way, and I want y'all to really consider this shit. If the feds couldn't figure out that this shit in a music video, which is easy as shit, you could have talked to the director. You could have did all of this shit. Y'all had damn near 3 years to do this shit. Y'all couldn't be bothered to do this? That's why I said if it was centered on real evidence, it would be about the evidence. They trying to introduce a music video now that is literally about D-Thing. This shit ain't about no goddamn King Von at all. But they tried it anyways. And the judge, he knows as soon as they see the video, that's enough to go, shit, he's a bad guy, scary guy. All these things, they holding up, doing like this. Could be saying they've been double dutching and all that, but hey, everybody don't jump rope no more. But the feds have done a lazy ass investigation as far as Lil Durk go, because it's all about the money, in my opinion. Here's what we know. We know that the songs that they try to introduce have a shit ton of meanings in them. We know that that music video that they try to use was full of shit. We know that they ain't introducing all of this shit. We know that they ain't doing what they supposed to do. Why? Because ultimately, the feds might mess around and say, you know what? Okay. You know, let's go ahead and get a guilty verdict and let's offer Lil Durk something like 10 years. Something like 15 years. You already got your time served. You wrap that shit. You might get RDAP. You come home maybe 7.5, 8 years and call it a night. That's a very high possibility. Now, some of y'all will go, well, damn, Nash, nah, they just put on this dog and pony show for this murder and shit. By the evidence that we just seen, do you really think they did a thorough, impressive job? Do you know that if they would have bought that damn video in there, and the moment that the word lookalike would have came from their mouths, and the person would have said, that's not a lookalike, that's from this video right here and this video right here, And all they would have had to do was sit with their arms folded like this and look at the juries and ask the guy to say this shit again. And the feds will get to sweating. The feds only care about a conviction and they care about the penalties that happen afterwards. They only want to say Lil Durk is guilty. That's all they want. They want him guilty of something. And when you break it all down, they want to go ahead and wrap up some money. Are they doing a good job of it? As far as what everything looks like, pretty decent. But application and evidence, once you start to dig deep, it's looking on the 60-40. 60% for Lil Durk, 40% for the feds. But you got to worry about all the jurors saying yes. And that's the part where I'm going to be fair, square, obvious, and honest. I don't think the feds could pull it off. But do you weigh that to chance is the question. I ask y'all that. Subscribe, turn on the bell, stay notified, and share to keep y'all people aware. Make sure y'all hit that subscribe button and that like button, please. Thank you, thank you, thank you. Click right here to see how Krishan Rock, blavity. Boy, this shit getting real in the field. Click right here for that video or click right here for the playlist, and I will catch y'all in the next one. Y'all come on back now, you hear?